All right, so we started with the intro part and difference, plus we have few more things like history, application of the legislation, where is it that CPC is applicable. Then we have jurisdiction of Code of Civil Procedure. Okay, so that part. Previous part, it's clear, right?
Yes, yeah, it is clear.
All right, so one more part we have is like the history of Code of Civil Procedure. As such, I have not seen questions being framed from this part that what was the history, write something on history as such. But yeah, it is like a small topic where we need to know what legislations were there before Code of Civil Procedure came into force. Okay, so before 1858, we were not having any set process for the civil suits. Okay, how civil suits will be settled or resolved, we were not having like a uniform rule for that. It was different for all the different parts. So to give uniformity to civil procedure, so that when a person is filing a case, when there is a civil suit, civil dispute taking place, the party will have some sort of understanding on how the case will go on. Like today, if we are filing a civil suit, we know how much of time it would probably take. We know what will be the different stages of that case. So that is possible only when we have uniformity of the procedure, and that uniformity will be set through some legislation or through some rules of process. So it was in order to give uniformity of civil procedure, Legislative Council of India enacted. The first one was called as Code of Civil Procedure 1858. Okay, so this Code of Civil Procedure 1858 was introduced, and then like we know today, President needs to give his assent. Same ways, it also took some while for Governor General to provide his assent, and it was on 23rd of March 1859, a year later, that assent was given, and this law came into like full force. But then what was the problem with it is that it was not applicable to the Supreme Court in presidency towns and to the presidency small causes court. Even though legislation was established, even though legislation was framed, it was not uniformly applicable in entire India. That again was creating confusion because different process will be followed, different rules will be there. So it was not serving the purpose, because main purpose was uniformity, bringing uniformity in how a civil suit will be resolved, and that part was not being done. This code, however, was not applicable, so it was not serving its purpose. It did not meet the challenges and was replaced by the Code of Civil Procedure 1877. Few years later, a new legislation was introduced because the previous one was not serving its purpose. But still, it did not fulfill the requirements of time, and large amendments were introduced. A lot of amendments were introduced, even then it was not serving the purpose. So again, in 1882, another legislation was introduced. It also was having its own defects or demerits. And finally, to like eradicate all of those shortcomings, all those problems that were there, we had Code of Civil Procedure 1908, which was enacted. Again, this legislation has also undergone a lot of changes in order to ensure that civil suits can be resolved quickly. It's not like for 10-15 years, people are just behind one simple case only. So in order to ensure speedy redressal of matters, a lot of changes were being introduced. Along with amendments in CPC, there are certain other steps also being taken. Like you would know, there is Motor Vehicles Act, right? For road traffic accident, people would file a case to ask for compensation. There, under that legislation, it said that civil courts are already overburdened with a lot of things. So let's introduce the tribunal there. For motor accident claims matters, let's introduce the tribunal and that tribunal will have sole authority to decide on such matter. So in order to reduce burden of civil courts, a lot of other things are also being done, like setting up of tribunals, setting up of some special courts, referring some matters for mediation, arbitration, and stuff like that. So apart from making a lot of amendments and changes in Code of Civil Procedure 1908, other steps are also being taken. And with all of those taken together, Code of Civil Procedure, even though it's such an old legislation, it's still valid and it is still serving the purpose properly. Okay, so basically before that also we had a lot of legislations, and from that we learned what all things were not working out, and we got the chance to introduce this one. Like when you study about sources of law, you also get one point, right, where legislation is a source. Do you remember that from maybe jurisprudence or something?
Yes, ma'am. Yeah.
You remember, right? So this is a very good example. How is legislation? How is legislation a source? Because it is through one legislation which is applicable. Now we realize the shortcomings in that and we can bring a new legislation. So this Code of Civil Procedure in itself is a very good example of that, that previously we had few legislations, they were not working out properly. Then we had new legislations, and finally we have Code of Civil Procedure 1908. Okay, so this is just like a small part that you can read for your own understanding. As such, I haven't seen such questions in the exam. Okay.
Yeah, from 1908, it was enacted and came into existence also.
Came into forces 1st of January 1909, okay, a year later. Just like, because it was 21st of March 1908 when it was introduced, so it took few months time. Okay, I think that date is also there somewhere at a later stage, but yeah, it was in March that it was introduced, 1908, and 1st of January 1909 it became applicable for all the matters which were there. And usually this time is given to make the arrangements which should be needed to make a law applicable, right? So might be certain officers needs to be appointed, some bodies need to be set up, certain processes need to be fixed, so a bit of time frame is given.
All right.